What is a non-disclosure? A non-disclosure agreement purpose is to protect confidential information that is disclosed, shared, received, or exchanged with customers, suppliers, and other parties. Therefore, a non-disclosure agreement should be used when individuals or companies enter consulting engagements, service agreements, strategic alliances. Depending on the circumstances, a person can either create a freestanding confidentiality agreement, non-disclosure agreement, clauses with an agreement that covers a larger transaction. A non-disclosure agreement binds a recipient of secret information from releasing to a third party or the general public. Confidential information. The types of information that are commonly defined as confidential include business and marketing plans, strategies and programs, financial budgets, projections and results, employee and contractor lists and records, business methods and operating and production procedures, technical, engineering, and scientific research, development, methodology, devices and processes, formulas and chemical compositions, blueprint designs and drawings, trade secrets and unpublished patent applications, software development tools and documentation, pricing, sales data, prospects and customer lists and information, supplier and vendor lists and information, terms of commercial contracts. Non-disclosure agreements are unenforceable if a trade secret or confidential relationship does not exist, the employer discloses the information to others not in a confidential relationship, or it is legitimately discovered and openly used by others. But what is considered a trade secret? The Uniform Trade Secrets Act, or UTSA, defines trade secret as information including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. Unilateral and bilateral confidentiality agreement. In a unilateral non-disclosure agreement, only one party will be disclosing the confidential information to the other party. Therefore, the recipient of the shared information will be the only one bound to the terms of the agreement. In a mutual confidentiality agreement, each party discloses confidential information to one another. Therefore, both parties will be bound to the agreement and required not to share each other's proprietary information. What is the period of a non-disclosure agreement? A non-disclosure agreement can run indefinitely or can terminate with the conclusion of the defined business purpose. Duration may also be determined by state law. Exceptions. Most non-disclosure agreements permit disclosure or confidential information with the purpose of evaluating the information and participating in negotiations of the agreement. Also, the disclosure or confidential information can and must be disclosed when the recipient is required to do so by court or other legal processes.